Good morning, everyone. Welcome back to Business Law 1. Today we're going to be discussing Chapter 11 in our textbook, and it's titled Consideration. We've been talking about different facets or aspects regarding what does it take to create a contract. In this particular chapter, we're looking at that third major prong. So we've talked about offers, we've talked about acceptances, and now we're looking at consideration. The idea of consideration is something that is very, very important and essential to most contracts that are created and entered into. So in terms of overall learning objectives, I would like for us to be able to understand what consideration is in a contractual sense, how the sufficiency of consideration is going to be determined, what are some common situations regarding consideration and how that is important, and when we possibly could enforce a promise that maybe lacks consideration by one of the parties. That's going to be the overall focus for this chapter. So when we talk about consideration, consideration is essentially what each party gives up in order to get something in exchange or for what they really want. And so, different textbooks, different authors, different professors are going to maybe word that a little differently, but that really is at the heart of what consideration is. I give often the example of going into a grocery store, and so everything on the shelf, if you recall, is an offer. When you put it in the basket and you take it to the cash register, that's your acknowledgement of acceptance. And then as everything gets rung up and bagged, that's when consideration occurs, and it's a simultaneous event. So, let's say, okay, so everything's bagged up, you're given the total, and so at that point you have to pay whatever the amount due is. And so if you have cash, if you have a check, if you have a debit card, a credit card, traveler's checks, whatever your medium of exchange is that you're utilizing, then that's what you give to pay for the groceries that you are now trying to purchase. And so as soon as the cashier, as soon as he or she receives those funds, then it gets processed and you're given your receipt, any change if that's applicable, and then you're given your groceries. So at that moment, in that kind of like very brief, 20 or 30-second, interaction, consideration is flowing both ways. If you're the grocery store, you want cash. You don't need groceries. You have shelves and shelves full of groceries. You want cash. If you're the customer, if you're myself or yourself, you want food. You want whatever it is that you just purchased because odds are cash you can't eat. It's not going to clean your house. So you need to actually have products so that you can consume or use them. So that really encapsulates the essence of what consideration is. It's this bargain for exchange that each side is willing to give up something because they really would like to have something else in exchange for what they're giving up. Sometimes I've seen it defined as like a detriment to one party while being a benefit to another, but again, that's a simultaneous type thing. If you ever have a transaction where consideration is one-sided, I don't want to say every time, but a lot of times that would be considered a gift transaction. So if I make a blanket offer to someone, I'd like to give you $1,000. No strings attached. They don't have to do anything. All they have to do is just okay, sure, I'll take it. All they have to do is say I accept. They're performing no consideration on their part. So if I show up and I say here's the $1,000, then okay, that's great. That's a gift. If I decide to be a jerk and I say, well, I changed my mind, I'm not going to give you the $1,000, there's nothing for that other person to sue over because there was no expectation. They didn't have to do anything. They didn't detrimentally rely on anything that I had stated. Gifting does have, certain kind of contextual settings, and we'll talk about gifting in future chapters. There's more details to the gifting process, but that really is at the heart of what I'm referring to when I say that consideration in most agreements does need to be flowing in both directions. So a promise is normally not going to be binding if there's no consideration for that promise. If again, just kind of reinforcing that gift notion that if you were not expected to do anything, then there's no real expectation that the other party who is going to potentially be giving up something that they're going to be compelled in order to act upon that. Normally, the law doesn't really question the adequacy of consideration. So, in terms of the bargain for exchange, a lot of times judges, they're intelligent individuals, and but they're not business persons. And so let's say two companies are negotiating a contract for goods or services. Maybe one company wants to just move inventory, and they really, maybe they accept that this time around they're not going to make a profit on this. They're just trying to just get this inventory out of their warehouse. They might even be willing to sell it at a loss, if it's like a closeout type good, just to get rid of it. And so, a judge isn't going to kind of intervene and say, well, no, you shouldn't have charged that, for that particular good or service. That was inadequate, for what maybe the value was of what was conveyed. So, as long as it's reasonable, and there's a pretty kind of broad kind of like swath that we're kind of applying to that kind of phrase, that reasonableness. Unless it's clearly unconscionable, or perhaps it violates some consumer protection statutes. In those very limited instances, can we kind of open up this idea of the adequacy of consideration. Some special situations that can arise. So forbearance, the idea of refraining to do an act that you have a right to do, that can be consideration. A great example, this was a case back in the 1890s, Hammer v. Sidway. It's a classic kind of contract case that all law students kind of read in their first year contracts course. It really established the adaptability and flexibility of the law, because prior to that case, there was really no basis to say that, well, if I'm giving up the right to do something, is that not consideration? Because I mean, I have a right to do it, and if I voluntarily waive that right because of a promise that you're making me, should that not be consideration on my part? Even though I'm not really actively doing anything, it's more like I'm actively not doing something that I have a right to do. So there was an uncle and a nephew. And the nephew at the time, he was younger, and he was kind of hanging out with the wrong crowd, and he was gambling, drinking, that kind of thing. And the uncle, who really cared about the nephew, decided, look, he approached him one day and he said, look, I'm concerned about the friends you're hanging out with. I'm concerned about your gambling and drinking. I will give you, this sum of money. And it was, I think, roughly equal to about $50,000 in today's currency. I will give you a sum of money if, for the next period of years, you stay out of trouble, you stop drinking, you stop gambling, and you start hanging around, better quality friends. And at the time, the nephew had the right to drink, had the right to gamble, had the right to, First Amendment freedom of association, hang out with whoever they wanted. And so, the nephew agreed. And so, after this period of time had reached its conclusion, the uncle acknowledged what the nephew had done and said, excellent work there. And he said, look, I'm obviously very good with money. He said, let me continue to manage your money, and it'll grow even more. And the nephew was like, that's fine. So a few more years passed, and then the uncle had died. And the executor of the estate, saw this obligation that was owed to the nephew. And he said, basically, I don't want to pay this in the name of the estate because the nephew didn't do anything. And so the nephew sued, to kind of challenge that decision by the executor. And the judge in this case said, consideration, even though we have historically looked at it as an active thing that both parties are, giving up or exchanging, we're also going to consider the fact that, if you have a right to do something and you voluntarily waive the right to do that because of a promise from another side, is that not really what consideration is anyway? So the nephew was able to prevail in that case. But a great example of how the law continually adapts, tries to achieve more just results, given unique situations that arise. Another special situation that can arise is what are called pre-existing legal obligations. So if you already have an obligation to perform, let's say you're already in a contract where you're getting compensated. If you want to try and get supplemental compensation for exactly the same thing that you're currently being compensated for, then that's not going to be permitted. That's like double dipping. And so if you already have this legal obligation, then that's just an affirmative duty that you bear at that point, and you cannot expect to have someone else give you additional consideration for what you're already being compensated for. The last one there is past consideration, and normally past consideration is not consideration for a present or forward-looking contract. Best example there that I've seen, this was a couple of decades ago. There was a retiring CEO, and so he had a personal assistant who had been with him for many, many years in this corporation. And so as he was about to exit and kind of enter his golden years, what he instructed the legal department to do was she had, I think, 3 years left on and before she could retire. He said, keep paying her until she reaches retirement, and then when she reaches retirement, obviously stop paying her, and then she'll start claiming her retirement benefits. It was put in form of like a legal, like a letter, a memorandum, and so she received that. And for months after the CEO retired, she kind of retired, quote unquote, also. So she was getting paid even though she was not working. The new CEO comes on board, and you get to know the company, you get to know the people, the personnel, the inner workings of this enterprise. And the new CEO was inspecting the books and realized that there was someone who was getting paid that he did not know who this person was. And so he dug a little deeper, talked to HR, and they explained the arrangement that the outgoing CEO had made. And he reviewed the memorandum and he said, just stop paying this person. I mean, she's not doing anything for our company. Why is she getting paid? So the paychecks stop. And obviously, she sues. And, at court, they look at the actual memorandum that the outgoing CEO had drafted for her. And it basically said, for all of her years of hard work, he wanted to allow her to retire a couple years early, but still get paid until she reached that retirement age. And that language, for all the years of hard work that she had performed for the company, she was paid for all those years. She wasn't owed anything. And so, there was no expectation for her to do anything going forward. Now, and so unfortunately she lost in that particular, that case. She lost that case. But, you change the wording a little bit and you can satisfy past consideration that issue. So had the memorandum said, maybe once a year when our corporation does taxes, because you know so much about the company, if you'll come in during tax season and help, the accounting department, kind of like complete all of our tax documents, then, you don't have to work the rest of the year. Or maybe as we hire new employees, if you'll come in periodically, maybe once a month or once periodically, and help train them, something. Remember, we just mentioned in a previous slide, we're not going to question the adequacy of consideration, but there has to be something that the person is expected to do. And so even if it was, something extremely minimal, the new CEO would have been obligated to keep paying her. Odds are he probably would have said, this is ridiculous, just let her stay home. I don't want to see this person. That's probably what the new CEO would have done. But because she had no expectation of doing anything, essentially for the paychecks she did receive, those were just gifts. That's all that was. The other thing that the outgoing CEO could have done, besides incorporating some element of consideration on her part for the remaining 3 years of her employment there, another thing the CEO could have done, the outgoing one, was just giving her a lump sum, and so just do the net present value of 3 years of salary and cut her a check and say, you're done at that point. And, and as soon as she cashes it, there's nothing that the new CEO could have done because it would have been a gift. So, there were different options available. It's just the outgoing CEO just really, he didn't kind of, dot the I's and cross the T's, so to speak, in terms of protecting her interests should the incoming CEO decide to challenge it, which he did. There are some very limited cases where we can say there's an exception to consideration. So if we're talking about truly charitable organizations, so nonprofits, whether it's you know, a religious-based nonprofit like a church, a synagogue, a temple, or if it's a secular type organization. It could be, you know, for, you know, disease research. It could be for, you know, environmental protection, whatever it is, just as long as it's a nonprofit. Um, the pledges that donors make to these organizations, you know, obviously there's a wide range of types of donations. Some people donate, you know, 20 bucks a month, and, you know, so that's small in the scheme of things. Um, but then there are larger donors who will donate 6, 7 figures to these organizations. And a lot of times those organizations, they rely on those large donations or the promise of those donations. And so if you back out and say, well, I changed my mind, I know I promised to donate $1 million to your organization, but I'm not doing it now. You know, sometimes those organizations take those pledges and borrow against them so that they can, you know, have the funds immediately available. And because of that, we give charitable organizations essentially an exception to the consideration requirement, because they're not necessarily giving you a physical product or necessarily a service. They might make you feel good by making a donation, but you're not really getting anything tangible. So we're going to say, as a matter of public policy, that we're not going to require those charities in order to, you know, we're not going to require them to produce what is normally considered consideration. The other type of exception is what's called promissory estoppel, or also known as detrimental reliance. And so here, if there is a promisor who makes a promise that lacks consideration, you know, and the promisor knows that whoever is listening, the promisee, is going to rely upon that promise and act upon it to their detriment, then we're going to enforce that contract. I know that sounds kind of confusing. The best example I've ever seen of detrimental reliance is the case of Lamborghini versus Chrysler. And so I won't read all of this to you. It's a fascinating case if you all, you know, want to take the time to read this after you watch this video. But what had happened was, in the 1980s and early 90s, Chrysler, you know, well-known auto manufacturer of the time, mass production, huge, multinational corporation, produced all these cars. And then you have a much more, you know, kind of niche auto manufacturer, Lamborghini. And so, you know, they're known for, you know, immensely well-designed and well-produced vehicles, but they have an extremely small production. So Chrysler acquires Lamborghini, and their theory and reasoning why they acquired Lamborghini was to try and bring mass production to this elite kind of brand. So, you know, they had come up with a few models. You know, they had, you know, some schematics. They had, like, you know, some testing theories that they wanted to apply. And so they wanted to create, you know, a less expensive version of Lamborghini, but something that would be more affordable to the masses. So instead of a car, you know, because normally Lamborghinis are, you know, easily $300,000, $400,000, $500,000 each or more, depending on features you have. You know, Chrysler was thinking, well, if we can get something that's maybe under $100,000, a lot more people can, that's more affordable. And so, you know, bringing their mass production expertise and kind of and aligning that with, you know, the production of this very elite brand, Chrysler thought this would be a win-win. So, you know, after they acquired Lamborghini, they reached out to all the distributorships, of the dealerships globally. And so, you know, memos were sent out. They had meetings, and so no explicit contract was entered into with all of these dealerships, but it was, you know, it was made very clear by Chrysler, the parent company, that this is going to happen. You know, we've got some prototype models already fabricated, and we're going to get ready to kind of, kind of like tool up all the necessary equipment so we can mass produce these. So, you know, if you've ever seen the Lamborghini dealership in any, you know, town around the world, they're fairly small. I mean, these are small showrooms. And, you know, their parking lot, you know, is very limited in size as well, because, I mean, you know, they may have 5 or 10 cars, if that. I mean, that's how elite this brand is. And so one of the dealerships in Britain, you know, they said this is an exciting opportunity, and they listened to what Chrysler, you know, had stated, all those promises. And what they did was they actually borrowed a lot of money and they kind of upgraded their facilities. So they expanded their operations. They acquired a larger parcel of land so they could have an increased size of parking lot. They hired more mechanics because, you know, if you're a Lamborghini mechanic, that requires special training and certification. So they really kind of expended a lot, you know, because they wanted to be ready on day one to receive this fleet of new Lamborghinis, this new model, so that they could sell it. So a couple of years go by, some technical issues arise, and Chrysler ultimately comes to the determination that this is not going to be feasible anymore. So they just reach out to the dealerships and say, we're very sorry, but this isn't going to work. So we're still going to deliver the normal production run, which is very, very limited production. So the one dealership, and there were others, but the focal dealership was the one in Britain. They went out of business. They went bankrupt. And their theory of suing Chrysler was that if it wasn't for the promises that Chrysler had made by being the new owner of Lamborghini, you know, even though no contract had been entered into, there was this idea of detrimental reliance, and we wouldn't have expended, you know, all of this, you know, capital and borrowed all this money to, you know, increase our building, our parking lot, staff, mechanics, and everything. And it was a classic case, and the dealership did prevail against Chrysler. But again, it shows, just to kind of go back a slide, it's, you know, it's a great example of an exception that we make under the law for consideration. Normally we want consideration. You know, we want to be able to say each side has given up something in order to get something that they prefer in exchange. But in these kind of exceptions, we're going to set that requirement aside, again, because of the greater interest of justice. So anyway, I hope that this explanation helps better understand a very complex area of the law and of contract law. If you have any additional questions, as always, please feel free to reach out to me anytime. You can call, text, or email me, and I'd be more than happy to get back with you as soon as I can. But have a good, safe, and productive rest of the week. Thank you so much.